Good afternoon, everyone. Well, I think my topic pretty much covers a lot of what has already been said, and will, of course, be dealing with some of the specific items of duties and responsibilities which have been identified for directors and key management personnel in the context of the Companies Act. As fate would have it, it is me who stands between you and your lunch, so I'll try and keep it short, although, delicious at the same time. I think one of the more important things which has come out of the new Companies Act is the codification of duties of the directors. Traditionally, it was the domain of the concept of a fiduciary responsibility that a director has towards the company, which basically formed the essence on which a director's performance or his obligations or his role in a company was always tested. And there are various case law which have provided adequate number of grounds and various criteria on which the performance of a director is judged. What we see in the Companies Act is basically the section 166, which has actually codified and put down in about 7 odd provisions what is the responsibility of a director towards the company. If you would see, none of the concepts which are being brought about here are really fundamentally new. If you do some amount of research, you will find that there is a lot of case law which already exists on each of these points. However, by virtue of it being codified, I think it makes it explicit to everyone who is acting as a director of the company that at the very least, this is what is expected of you. And if you were to go to the language of many of these provisions, you will, of course, see that there is still a lot of subjectivity in how it has been drafted. For example, it was mentioned the whole concept of a conflict of interest. Now, if you see, one of the provisions under 166 says that a director should avoid or should not be involved in any situation where he may have a direct or indirect interest which conflicts or may conflict with the interest of the company. Now, who takes this call? Of course, it's a personal call which a director may have to take, unless you want to say that the only instances where a conflict of interest may arise are the ones which are provided in section 184, which is basically to say that, wherever you have the 2%, you're holding more than 2% shares, or, or if it's a contract with an entity where you are a partner or an owner or a member. I'm sure the intention is not to keep the conflict of interest limited to such very, very objective criteria. I think the intention of the regulator is to keep it more broad-based, so as to be able to, basically ensure that the obligations that the director has towards the company are at all times wide enough to encapsulate any off event which otherwise may have escaped attention or, the drafting of the provisions. So just to sort of quickly run through some of these basic duties which have been imposed. Of course, you have to comply with the Articles of Association. The second bullet on the slide is a little more interesting, wherein I think what the objective has been, and traditionally how the director's role has been understood, is to further the interest of the company, and indirectly by that it means the interests of the shareholders of the company. However, what you also see is, and interestingly to be put in a form of a law, is that it also has to be in the best interest of the employees, the shareholders, community, and the environment. So it is really, really wide in its scope, and so as to, again, I think you will have to take a leaf out of the corporate social responsibility part of the statute as well, wherein not only does the director have a responsibility towards the company, or the company doesn't have a responsibility only towards the shareholders, but also to the community in which it is located, as well as the immediate environment in which it operates. So that having been codified means that the responsibility or the consequences of every action that a company undertakes will have to be at least considered from an environmental or an impact on the local community perspective. This will be very useful to look at in context of some of the more recent events that we have in the mining sector, or some of the other more environmentally challenging situations that many companies are facing these days. Of course, exercising of duties with due and reasonable care, skill, diligence, these are well-recognized principles as far as directors' duties are concerned. We spoke about conflict of interest. Similarly, you will have to avoid any undue gain to the director or any of his relatives, etc. And assignment of offices, which of course also existed in the previous version of the Companies Act. Just to touch upon the liability part, if you are found in violation of any of the duties that you were supposed to perform as a director, contravention will not be less than 1 lakh and can be up to 5 lakhs. And of course, if you have made any undue gain, then the entire amount of such gain will also be, called into question. Um, Without trying to sort of go into the list of each and every provision which identifies a liability for the director under the Companies Act, I think some of the more important ones, if we can just quickly look at, is, of course, for misstatements in the prospectus, clearly civil liability has now been identified in the statute. In addition to criminal liability, you may be civilly liable also for any losses which may have been caused by people who've been relying on the statements that you've made in the prospectus. Of course, if there is an element of fraud, then the repercussions will be even more severe. Interestingly, the exception that was provided in the previous statute, whereby a person could withdraw his consent upon becoming aware that an untrue statement had been made in the prospectus, is no longer available. So you pretty much have to be spot on with the prospectus and what is stated therein, and especially in the context of, let's say, independent directors who will now be required to sort of examine some of these things in some more detail and convince themselves, or at least assure themselves of the veracity or the completeness of information, so as to be able to sign off on many of these documents. So that exception going away means that the responsibility or the onus on the directors is even higher now. Of course, disclosure of interest. If you do not disclose your interest as has been provided under Section 184, there are certain penal consequences for that as well. And of course, contracts which have been entered without disclosure of interest are voidable at the instance of the company. Just to sort of quickly highlight some of the differences in context of disclosure of interest, I think the register of contracts for disclosure for recording the interests. Disclosure of interest now also will include disclosure of interest by the key managerial personnel of the company and not only the directors. And the exemption that existed for contracts up to a value of ₹1,000 has now been raised to ₹5 lakhs. So I think there's some amount of breathing space available for some of the small value contracts which may require a disclosure of interest. Insider trading, as was touched upon by Mr. Parekh as well, I think there is a whole lot of confusion around whether this apply only to companies or whether it in fact will apply to all the companies under the Act, which makes life a little difficult for us as transactional lawyers, because it will clearly hinder the effectiveness of due diligence and some of the other standard practices that one undertakes while conducting a transaction. So I think a clarification of this on this particular aspect is very eagerly awaited, so as to be able to take a call on how and in what form and fashion do we conduct our transactions and how to advise our clients on that. Some of the other liability-related issues could be, of course, the number of directorships. You have a clear identification that at best you can only be a director in 20 companies, and out of this, only 10 can be public companies. If you violate this, of course, then there are certain penalties which may be imposed.